Because this is a discussion that has two compelling arguments. So, the former Chief Justice contends that the process that has been carried out so far is to remove her as Chief Justice. No process has been carried out to remove her as a Supreme Court judge. Therefore, the warrant to remove her as both is not lawful. She believes that she remains a Supreme Court judge. Kofi, I think the simple question is, if you have been found to have engaged in stated misbehavior, how can you remain a Supreme Court judge?
Well, good morning again. Point is this. So let's assume you are one of the is it journalists or anchors of Super Morning Show, and then you are appointed to be the head of the team. All right, and for some reason you are removed as the head of the team. Does that mean you are removed from being an anchor or a journalist on the Super Morning Show? I am saying this because on radio we can't go through all the things and we need to simplify them. The issue is this. There are justices of the Supreme Court. In our law, they are appointed in a particular way. Then there is the Chief Justice, who is one of the justices. In our law, she is appointed differently, goes to vetting differently. There is in our law a process for removing justices of the Supreme Court. That is different from the process of removing the Supreme Court justice. I am saying this simply because even in our law, there is the admission that there is a difference in those two positions. Now, what we all must understand is that as long as there is room and the process have not been exhausted for a matter that is in contention to be declared or properly sorted out or explained, we should use that option. What CJ Tokono is doing is useful for all of us. You hear people talk about, oh, it's not good. She's disgracing herself. Why is she seeking to come back? Honestly, the rest of us are better beneficiaries of this than CJ Tokono. Just like we keep quoting the Ejetin case. When some of these things are brought to the Supreme Court, it gives opportunity to express them better, explain them better, give more elucidation on them. So what we must note at the beginning is this. She does have the right to bring that matter. Because until there is a judicial pronouncement on the matter, it is not final. And two, there is persuasive argument in law that what she says may be true. To the extent that there has not been any variation on it, all of us should hold our horses and not sound as if we know how this is going to go. At least let the process be gone through and let there be a clear declaration. Then in future, we don't have any of these problems. So for me, I'm not saying it is right or it's not, it is good or it is not. I'm simply saying it is useful to clarify that area because it is not clear. There is a difference in the Supreme Court justice and the Chief Justice. And the things that the Supreme Court justice does, which is mostly being a judge, are different from what the Supreme Court Chief Justice does, which include administrative work. And the other justices don't do as much as he does. So there is persuasive argument that if you say I cannot be head of the team, one of the justices becoming a Chief Justice can no longer be a Chief Justice and perform those administrative duties. And I have earned my place already as a Supreme Court Justice. Then if you use the bullet that removes a Chief Justice, it cannot kill those two birds. But there is also an argument to the contrary, which I believe my good friend and colleague will canvass here. What we need to appreciate is that it is a proper case to come before the court and let the court handle it, so we will all be better for it.
Kofi, blessed here. I just wanted to point you to Article 128 of the Constitution, which talks about composition and the mode of exercise of judicial power. You look at 1284, and it reads that a person shall not be qualified for appointment as Justice of the Supreme Court unless he, and we can use that to replace she, is of high moral character and proven integrity, if not less than 15 years of standing as a lawyer. Does that not tie, ethics and standards to who qualifies to still remain on the bench of this country?
Well, you're right. But that's the point. She qualified to become a justice of the Supreme Court, which means she passed all of that. Then when you become a justice of the Supreme Court, you are picked from the team to become the Chief Justice. Okay? Now, when you are removed as Chief Justice, it does not mean that the qualification that brought you to being a justice of the Supreme Court is all of a sudden removed. Because what moves you from the justice of the Supreme Court to the Chief Justice is different.
Is stated misbehavior not a proven case of breaching high moral standards or character as stipulated in 128 of the Constitution?
That's not the issue. The point I'm making is that...
Why is that not the issue, though?
Well, that's not the issue because he passed all those things to become a justice of the Supreme Court. Okay? And now she's moved as a primus inter pares to become the Chief Justice. She's all of that plus. If she is dropped from the position, like I said earlier, if you are made the head because they think you have some leadership, special leadership qualities, and therefore you're made the head of the team at the, what is your program called? Morning show. Okay. And for some reason, you are removed because you didn't do that job well. I think there's an argument that you should be returned to your original position. There is this thing in HR called being promoted to your point of ineptitude. Some people are good at a point. When you elevate them, they may not be that good at that point. So I'm simply saying, the processes have not been exhausted. There is an argument to be made. Whether it will go in her favor or not in her favor, it is useful for the rest of us that this matter be put to rest once and for all. What I say, or what my colleague Martin will say, is not the law. These are our views. It is properly before the Supreme Court. Let them take a look at it and let them make a decision on this matter. And then we'll all the advice going forward. But I do think that she does have a case. Because in future, if you become a justice of the Supreme Court, you may be very suited to become the Chief Justice. But if you look at what is going on now, and you are giving the Chief Justice, which can help the whole country, you will refuse. Simply because anything, including making a mistake on accounting, can lead to your removal of the Chief Justice, and then you also get removed as a Justice of the Supreme Court. Very good people will refuse to take that position simply because it puts them in bigger jeopardy than the benefits that they gain from being in that position. So I'm simply saying there is room to look at this and let the justices of the Supreme Court deal with it.
Right.
In a constitutional republic, nothing is final until there's a final judicial pronouncement on it or the statute of limitations passed. So to the extent that she has not exhausted all these, I think it is proper to bring this matter. People are giving her advice and saying it is not good, you are disgracing yourself, you should stop fighting. All of those things are not things are the law.
Okay.
She is good enough to advise herself, and she has advised herself. I am happy that she's doing it, and I think I'm waiting for the outcome.
All right. Now, Martin Kpebu is here, but just before I bring in Martin, I would like to get your reaction on this very quickly. There are some who suggest that this is a matter that has actually already been ruled on by the Supreme Court. And they point to Justice Kpega's ruling in the case that came before them, Ghana Bar Association versus Attorney General. This was back in 1995-96. And I'm just going to read because there's a very short paragraph from Justice Kpega. Without mincing words, the ultimate result this action is intended to achieve for the plaintiff is the removal of the second defendant as Chief Justice of Ghana, and as a fallout, a judge of the Supreme Court. The substratum of the plaintiff's case as we have stated earlier, is that the second defendant is not a man of high is not a man of high moral character and proven integrity to be the Chief Justice. Ipso facto, a judge of the Supreme Court, since the qualifications are admittedly the same. For if the second defendant is disqualified from occupying the post of Chief Justice on grounds of lack of integrity, I do not see how he can continue to be a judge of the Supreme Court. Does this apply?
It also has persuasive application. But again, I think there is room to put this matter beyond conjecture and contention. You see, somebody does something which is read as meaning that they don't have a high moral, whatever it is. It draws you into the facts of the matter concerning C.J. Tokono. There's a whole argument that even the issue of Pedio's etc. should not necessarily be an issue that she to answer to in the way it is being dealt with. Because there were auditors, etc., that handled those things. And then there is the issue that it was not proven beyond reasonable doubt that this was clear, etc. You know, I keep saying, there is a reason why we have a Supreme Court, and when we have doubt, we go before them. Even the justices of the Supreme Court, upon further examination of a matter, can depart from their earlier decisions. So this is useful. If we have more time, you will hear both arguments, and you'll be persuaded by some. So for me, the merit of the matter is why it is before the justices all over again. It is useful for them to go through it. If I had the time here, I may be able to canvass reasons why I think an absolutely good Chief Justice, and I'm not saying that is what C.J. Tokono was, but I'm saying for principle, that perfect or absolutely good Chief Justice, who is found culpable in things like what we are discussing concerning C.J. Tokono, Pedio's etc., should not be removed from her post per se. Because as many have said, including the Justice Sofayaku, it does not rise up to that point. To the extent that there is that doubt, should that rise to the point of removing her from two positions, which very rarely people get to? I don't think we are doing ourselves the best favors as a country to proceed that way. So to that extent, I really want to hear the reasoning behind why this should remain so going forward. Because it will influence what happens in future. So it is very good that she's taking it where she's taking it. And I want to hear what the justice has to say about it.
Quick clarification. She's taken it to the High Court.
Yes, the High Court.
Taking it to the High Court. All right. So Martin Kpebu is here. This is an exciting conversation to have you both on. All right.
Yes.
I mean, this it's really intellectually compelling. But you see, for some, it is actually quite a simple matter. It's actually quite simple. That 1464 exists. It is there.
Yeah.
So why go through a process that doesn't include 1464 and then at the end of it release an outcome that includes the outcome of 1464? Why not simply go through 1464 as well before you then have the outcome of 1464? By the way, I'm using numbers, but I'm simply saying, Chief Justice removal is under 1462, I believe. Five. Forgive me. Right. So you've done 1465, and you've removed her as Chief Justice. You have not done 1464, but you have removed her as Supreme Court judge. Why? 1464 exists. So go through that to remove her as Supreme Court judge.
Okay. No, I would not, because the 6, the 1464 and 5 are many. Let me just be sure that when we said 5, that was it. Yeah. You see, let's do this, Kojo. The simple matter is this: the Supreme Court has held Okay, so 1466 is a Chief Justice.
1466.
Yes,
Thank you.
Exactly. So 5 is the recommendation for the removal of a Superior Court judge.
Right.
Look, it's simple. The Supreme Court has held, in 2 cases, and you even 3, because you mentioned the Aban case. In the J2, and then in Justice Tokonu's own case, they say it's a consolidated process. It's 2. It's a consolidated process of removal as a Supreme Court judge and removal as a Chief Justice. Let me read a short dictum by Justice Tanko in the recent one. So if that is the case, I'm wondering why they didn't take issue with the ruling of the Supreme Court when it was given. Because Justice Tanko was very clear, Amadou Tanko, was very clear that, look, this process involves the removal of the Chief Justice as Chief Justice and also as a Supreme Court judge. That's why, let me just go straight to it. It says this. I have arrived at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge. Chief Justice and as a judge is 2. Then we go to the one you read earlier, Pega. Then there is a J-Chum. I've been scrolling since I came because I wanted to get the page in a J-Chum. A J-Chum, a J-Chum case, that's Dateba. He gave the the lead opinion of the Supreme Court, and Justice Ofekufu and the rest concurred. Of course, Justice Ofekufu later on wrote a small opinion where she stated her misgivings about the nebulous nature of stated misbehavior, asking that there should be more flesh, and also in terms of the procedure, more flesh. But generally, she concurred with Justice Dateba. So it's been very, known to us in the legal community that it's a dual process, 2 in 1.
That first reference you made,
yes,
and the quote that you read,
yes,
I note that, and I'm just trying to be fair here, I note that he says that the procedures that they are going through may have, he said, may affect Justice Tokonu's career as a Chief Justice and as a judge.
Yeah.
I don't know that we are being fair if we say that means may remove her as a Chief Justice and as a judge.
Oh, that's the meaning.
Because you can affect her career as a Chief Justice in one way and affect her career as a judge in another way.
I get it. The devil's advocate.
Yeah, it's only fair to point that out, right?
Yeah, why not? But for us as practitioners, it's not a question that really excises our mind that much. You see how Blessed took it, and you yourself, you earlier referred to it. It will be incongruent to say that those facts that have been proven against her relate to her office only as Chief Justice. Those same facts, let's go over this. We lost over 300,000 in terms of per diem and tickets, right? And somebody is saying that these are trivial. This cannot meet the threshold of failing to keep the public purse, and so the Chief Justice cannot be removed in the dual capacity. We are joking. Look, millions of our citizens don't earn even 100,000 Ghana cedis a year, annual salary. Millions. When this matter came up and we're making the $10,000, even if we took it today, even since this government came at a point we're at 10.5, right?
Yeah.
Even if you call it the lowest, 105,000. I was shocked that some teachers who had been in the classroom for over 15 years said, look, they don't earn up to 100,000 a year. You ask policemen, etc. So millions of our citizens. So those who are saying that these things are trivial, and I see that they've lost touch. They really don't understand the incomes of Ghanaians. These are graduates. People have gone to school, finished university 15 years on, can't earn even 100,000 Ghana cedis a month. And this is money that has been given to a daughter on one trip, not more than 2 weeks, $10,000 per year. Then the spouse also gets 6,000 on another trip, right? No, that's a misapplication of the funds. the public purse wasn't well kept, and the other grounds. So look, they relate to their dual roles. And let me make this clear. Look, the case has been sent to the High Court, right? But if you look at what Justice Tokonu is looking for, the High Court can't grant that, because that would be an interpretation of the Constitution. So it means they have to go to the Supreme Court. You heard even Kofi refer to the Supreme Court twice or so, meaning that in Kofi's mind, he thought that the case is in the Supreme Court.
Why do you say it would be an interpretation of the Constitution?
Because of these various statements we've read out, quotes from the various cases. So you've seen that our judiciary have shown that for them, when the person is being removed as Chief Justice, the person is also being removed as a Justice of the Supreme Court. So to go and ask a junior judge, a High Court judge is senior, okay? High Court, Court of Appeal, Supreme Court, they belong to one class. But within that class, the Supreme Court is senior to the High Court. So a High Court judge, in view of such statements, would not. Either the judge will throw out the case, or at best say that, okay, I'm setting down an interpretative issue to go back to the Supreme Court. Yes.
Lawyer Kpebu, don't you feel we're having this challenge because the scope for stated misbehavior is a bit vague? Don't you feel that's where the challenge is coming from?
Oh, you see, yeah, I understand your question in two parts. Right. Yes, the scope of stated misbehavior definitely has not been fully expounded in our law. That one you are right. Okay, and even so, we take them case by case. It's piecemeal, which is not good, because we need the law to be certain and to guide. So I hope that the new law that Mama Yarga referred to, that they are passing, I hope when it comes out, it will have a very comprehensive meaning of stated misbehavior, right? Yeah, so that's it. But on the facts of this case, I have no doubt whatsoever that this case is a textbook example, classical case of stated misbehavior. No doubt at all whatsoever. This case doesn't give any doubt about the meaning of stated misbehavior. These are very grievous. Abuse of office. Okay, they even sound in crimes. It's just that, you see, we all feel sorry that Justice Tokonu has to go through. Day one, when the petition came out and I was interviewed, top story, I said that, I remember, was it Evans who asked the question, what would be my advice for Justice Tokonu? I said, resign. Because from what I heard, it was an open and shut case. And to be candid with you, we had heard these things before. The audit report that flagged this misapplication of funds, they had been there, by the previous administration. She's an Ekufuado appointee. Ekufuado, who born dog. Many Ghanaians were even scared. Even talking on radio against Ekufuado, people would see me and say, hey, they will maim you, they will kill you, there's a hang. This is our timid nature. We just hope that, we improve with time. So these are facts that people always knew. So the moment I heard those facts in the petition, I said, look, resign. Even though I also reckon that, yes, there are some Supreme Court decisions that say when the process starts, the person. No, but I believe that, look, if elderly statesmen had stepped in, they could have negotiated an exit. Later on, you heard Amalba, NDC, they said, well, now he's head of road fund, right? Road Safety Authority. He said that at a point, she came to negotiate an exit, went away, and never came back. That would have been it. Look, you can play that first interview. When they asked me, what do you think? Because I knew that this was almost impossible to defend, I said, look, resign. It would have been better. Because even if you resign, and let's say they went on, we could say, so it's a default judgment, I didn't go, right? If history looked at it, say, if she had gone, she probably would have put up a good case. But once you went, cross-examine the persons, and now they've come after the decision, that's it. It's nailed.
It's funny. I'll be bringing back Kofi into this. I'm sure he has quite a lot to say. But it's funny. Every time this conversation comes up, one of the things that almost kind of slides by without being said is the fact that when Chief Justice Tokonu was, when she was defending her case, right? And we've picked this up afterwards because it was all in camera. It's only afterwards that things have leaked. When she was defending her case, she she considered all of these things to be administrative issues, and she explained her understanding of these administrative issues, and that she had acted based on her understanding, and that if her understanding is wrong, it doesn't rise to the level of misbehavior, because she didn't have a guilty mind, as you lawyers, would say. That has been the strain of her argument. But to you, it's open and shut.
Oh, open and shut. Look, there's no doubt that there is. That's all.
Does it not matter that she didn't have a guilty mind and that she was carrying out the procedure as she understood it, as her predecessors have understood it? Because one of the testimonies in this case was to the effect that they've been doing it.
Yes.
Right.
Yes. That.
So does that not, mitigate the situation?
Yes. So that is how come. Exactly. I like where you've landed. Very good. So it's because we know that her predecessors had been doing the same thing, right? That's why I kept saying that, no, then let her resign. She's not the first, so that she will get her benefits. That's the main reason. That no, so something could be negotiated, because the very audit report that flagged these payments as inappropriate flagged a certain previous chief justice and said, look, come on, refund. Your spouse should refund this money. And then it dates way back, even beyond the one who was asked to refund, right? So it's because of that thing. That's why I say, oh, she's not the first to have done this. Yes, we all know we want probity, accountability, right? So for me, losing the office was sufficient punishment. But to lose her benefits was like an overkill. That's how come consistently from day one. And if you ask me today, even though the decision has been made, look, as a nation, I mean, considering that she's not the first, blah, blah. Today, if you ask me, Kpebu, would you support a call for her to be given her benefit? I'll still say yes. Because, look, it really wrenches my heart. Because we all know this thing has been there for years. Others even probably abused it more than her. But they got off. I know it will bring a lot of backlash. But as I'm saying, I still think that we could do something for her. Right?
Do you think this is all about her benefits? Do you think this fight, this continued fight, going back to the High Court, is all about her benefits?
And well, I don't have a crystal ball, so I would not know. But it's possible it is part. Now, the second part of your question, the part where she said she had what do you call it? She didn't have a guilty mind, etc. Yes, it's not all the time that the law would require a guilty mind. We all know the famous law on causing financial loss. It's once it's willful, and being willful doesn't mean it's intentional. If you are reckless, you see, negligently. Yes, and in law, there are other offenses. You negligently cause something. It's also a form of, they say, will hold you. So it's not all the time, even in criminal law, it's not all the offenses that require, what do you call it, that it should be a guilty mind. You see it? Yes. The word intention for us is broader than just having a guilty mind. Let's put it simply. Sometimes if your conduct, if you are fully in charge of your mind and you undertake certain activities, the law imputes intention to you, even though in your mind you were not thinking negatively. Let's repeat. In law, when we say the word intention doesn't mean you should have thought in your mind that I want to steal or I want to do something bad. No. What we use is we look at the facts, the things that have happened. If they happen, so let me give you a typical example. So let's say Samuel Odame is standing here. Kojo, you take a gun. You know Samuel Odame is standing here. Then you shoot at him. Then touch wood. Okay, we will not say death. Then it maims him.
Yeah.
You saw Samuel Odame standing here and you shot. Even though maybe you thought that you want to shoot above him to scare him. In law, once you aimed at him and shot, you intended to. It doesn't matter that what you actually meant was just to scare him. So you aimed above, but it came below. No. You were in charge of your mental faculties. You pull the trigger. So we'll ascribe the end result to you. So to say that it wasn't with an intention to steal our funds, it's no answer to anything. It has nothing to do with anything here.
Kofi was making a point that I wanted to put to him on phone.
If you don't mind, when we come back from these messages, because I also can't wait to hear them.
Kofi, I was going to ask you, if a Chief Justice ceases to be a Justice of the Supreme Court when they are appointed, or once they are appointed as Chief Justices? Is that the case?
Right. So there is an argument there. Let me give you an example. You know the judges who are affected by Anas's expose, they were removed as judges. But the same reasons why they were removed as judges can cause the loss of their licenses as lawyers. Because moral turpitude is grounds for losing your license. Okay? But they were not removed as lawyers. We are making a point here that you become a justice of the Supreme Court by a separate set of qualifications, and your job is well defined. Then you are picked to become a Chief Justice mostly for administrative duties. And it's a different thing. And the point that is being made also is that the law, the Constitution itself sees them as different. Gives different processes for arriving at each position and also for removal.
Just a minute. Are you saying that can you become a Chief Justice without being a Supreme Court judge?
I am making the opposite argument, that you become a Supreme Court justice by a certain set of qualifications. Then from there, you are picked as a primus inter pares. So, if you are picked simply to perform administrative duties, those administrative duties are not what qualify you to be a judge.
Is that the description the Constitution ascribes to who a Chief Justice is? It's not limited to administrative roles, is it?
What is it as?
But she heads the judiciary. The judiciary goes beyond the judicial service, isn't it?
But what is that not? Is that the core duties of a judge to head the judiciary? She now becomes the CEO running that judicial institution. Let me make my point. Article 128 is for appointment. Something brings you to that point. Okay. Then when you get to that point, there is a separate process in the law for removal. That's a fact. So when you import 128 and use those principles for removal, it doesn't wash because, like I told you, losing your position as a judge does not make you lose your license as a lawyer. So that should be clear. Then you also should appreciate that the law itself sees those two things as different. All I am saying is there is a question to be answered there. Let me put it this way. If you are removed as Chief Justice because of an infraction regarding accounting, which paying back would have resolved, and somebody thinks that that is grounds to remove you as Chief Justice, the least that can be done will be that another process has to be gone through, and those reasons used, to remove you as a Justice of the Supreme Court. That would have been fairer.
Kofi, is causing financial loss to the state a legal question or an accounting question?
It is both.
So why then are you shifting away from that when it comes to the case of the former chief?
Because it doesn't make sense in this argument. Causing financial loss is not what we are talking about per se.
Because there's an audit report. You are limiting that audit report or finding to the fact that she's not an accountant. Yet an audit system has flagged it based on law.
To the fact that even though other people did it before her, which is not an excuse, and that in her case she had no intention to commit the infraction, and that there were accountants and auditors who could have easily dealt with it but didn't. Of course, she bears ultimate responsibility, but it has been said by people who are better than me that it does not rise to the position of removing the Chief Justice of the land. And I'm simply saying, where there are all these doubts, and even that has been done, you do not extend it to remove her from a different job which has nothing to do with these particular issues. And I've just given you an example that people who were shown to have collected bribes, etc., which is high-level moral turpitude. And if you are a lawyer and you are found to commit what they call moral turpitude, you can lose your license. These people who were judges were removed as judges, but they are practicing as lawyers. And I don't think there's a problem with that. If you want to remove them as lawyers, bring the same accusations against them to remove them as lawyers. But you don't knock them off one peg and then use the same bullet to knock them off the second peg. Okay. I am simply saying there is a point there to examine.
Right.
Justice Sanko's ruling was an application for a interlocutory injunction. the specific question being argued there was not for determination in that particular case. So it's persuasive. What we are simply saying is that it is a useful thing that Chief Justice Tokono is taking this matter where she's taking it. And yes, I even forgot that it is before the High Court, because clearly there will be constitutional interpretation issues in this matter. However, the High Court can deal with that, except they decide that it has to be interpreted by the Constitution. If some justice of the High Court decides that, yes, this is a matter that I can handle, somebody can argue with that. But I agree with Martin to the extent that I think this will end up going back before the Supreme Court. And right. I think rightly so. So we can deal with this matter clearly. We are not all agreed that an accounting infraction that affects the Supreme Court, the Chief Justice of the Supreme Court, should be caught for removing somebody from being a Justice of the Supreme Court when that has nothing to do with the competences required for performing that duty.
All right,
I think that question should be resolved.
Kofi, I think what when you say that we don't all agree that she's been, as you say, knocked off both perches, right? But we do all agree that she's been knocked off one perch. She's no longer Chief Justice. We all agree on that, right?
No. Again, I said, until there is a final judicial pronouncement on the matter, it is not done.
But even she is not disputing that.
This process, if she decides to challenge her removal as Chief Justice, it is within her right to do so.
She hasn't.
If we all are going to be working under law, if we don't want the law simply to be an act that anybody writes to achieve their goals, let's let the processes be gone through.
Yeah, but
so
Kofi,
if he chooses to challenge it, it is not final.
Kofi, she hasn't chosen to challenge it. She has chosen to challenge.
If she chooses to.
Yes.
You are saying it is done and finished.
I'm saying that she's not disputing it. She's disputing her removal as Supreme Court judge. She's not disputing her removal as Chief Justice.
In this matter, yes.
Okay. So with that in mind,
but I'm saying she still has a right to challenge the other one, and for all she will do it.
Fair enough. But with that in mind,
please, let's be clear. Let me make this point. See, the same issue upon which she was removed as Chief Justice came up as an audit issue. The auditors looked at it, they asked questions about it, and then they dealt with it. So it was no longer in the final audit report. Okay, that tells you that that matter has been dealt with.
All right.
So to the extent that it is grounds for removing her as Chief Justice, it's troublesome. She can challenge that if she wants to. But she clearly is within her rights to challenge that as cause for removing her as a Supreme Court Justice when no process has been gone through as the Constitution requires for removing her at that level.
Okay. Now, as things stand, Kofi, the reason for her removal as Chief Justice is stated misbehavior, not accounting infraction.
Mm-hmm.
It is stated misbehavior. Now, my question to you is, can a person who has been found culpable of stated misbehavior be a Supreme Court judge? Does that person meet the standard of high moral character and proven integrity?
If that person is found of guilty of some stated misbehavior, which she contests, it becomes a matter of opinion. To the extent that the people who have removed her have the power to act on their opinion, she has been removed. But she can challenge it.
She hasn't.
Again, I say, the same argument can be made for the judges who were removed in the Anas case. Must they lose their licenses as lawyers simply because something was found in another forum?
But Kofi, she hasn't contested it.
Hello?
She hasn't contested it.
Okay, so please listen to me. I am saying, if she chooses to contest it, she has a right to. She has chosen to contest it in terms of her appointment as a justice of the Supreme Court. Okay? So, the fact that she hasn't contested the earlier one does not extinguish her right to contest it in this area. Because I'm making the point that to remove a justice of the Supreme Court, there is a process. That process hasn't been gone through.
Right.
Somebody is saying, because you lost at that level, we are also using it against you here. And I'm
Okay.
saying there's an argument that is wrong.
Okay, understood. I'm going to take just a 2 minute response from Martin before we move on to the next issue.
Okay. Yeah, so far with what Kofi Bentil is saying, I think it's basically the same point that we explored earlier. So let's come to the matter he refers to as accounting infraction. Bottom line is that what did the infraction lead to? Or the end result of the infraction is that money went into the Chief Justice's family pocket. That's one, her husband, and then two, one of her daughters. So the thing you call accounting infraction, the end result is that money went where it should not go. So it doesn't help the discourse to just say this is an accounting infraction.
But it is a matter that was dealt with by the auditors.
Yes, let's come to that. No, not completely dealt with. You see, that also raises issues of the independence of the auditors, etc. That wasn't totally dealt with. And let's note one thing. Even when auditors finish, it's without prejudice, okay, to the right of the state to take other actions. Just like the way we say, okay, somebody can be dismissed from work, maybe somebody steals, is dismissed from the employment, and say it's without prejudice to the state authorities instituting criminal proceedings. We do the same even for our military. Yes, the military, they say, okay, we'll dismiss you. If the state wants to prosecute you too, it can be done. So crimes, yeah, you see. So there are many sectors of our economy where the law is that, look, your employer may take this and this decision, but it would have prejudice to the other available remedies. So there is no part of our audit service rules, okay, the Audit Service Act and the Constitution that says that if auditors are railroaded to clear you, and that's what I think it is, yes, because the auditors were very clear in their mind. And let's not forget, when the matter went to the committee, we all know Domlevo. We know Domlevo is very independent. You remember even last week when Abronye DC was incarcerated. Oh, Domlevo called, they said, Kpebu, what is this? Look at my Facebook page. I've spoken against it. And we all, jumped in and said, no, this Abronye incarceration is wrong. So you see, Domlevo's independence, that's Domlevo on the committee. It was very clear to him that, no, this thing, don't just call it an accounting infraction. It's a huge constitutional breach against the ethics, okay, of a judge, against the rules. And let's mention even one other thing. When you read the proceedings, you see that this per diem that they pay is actually contrary to the terms and conditions in the Chief Justice letter of appointment. Yes, so when you read the script, the one that leaked, you see Tadiosori asking the witness that, do you see that this per diem in this that was paid is different from the amount stated in the letter of decent conditions of service? Then the witness said yes. So that's it. So why that disparity?
So then if you are convinced without a doubt that what caused her removal as Chief Justice rises to the level of causing her removal as Supreme Court judge, then why not just go through the process?
Oh no! So from what the Supreme Court, the JHUM case, it's a dual process. It's consolidated 2 in 1. And in law, just as in accounting and other professions, okay, we have what we call substance over form. It's substance over form. We all knew that, look, this thing, she's going to lose dual roles. There's no doubt at all. These arguments are being made that, okay, let's get a full decision that squarely deals with this dual removal. So what Kofi is saying is that, look, the JHUM case and then the Justice Amadou Tanko dictum I've referred to, the question that was put before the court, head on to answer is not if a person is being removed as Chief Justice, that ipso facto is also removal as a Supreme Court judge. So he's saying that no question like that was set and put before the court to answer. That's what we call issues.
Understood. Right. Thank you for that. And I can't wait to hear your views on the thank you tour. I was to hear what they think about this sudden thank you tour of the NDC chairman, General Mosquito. It's an unusual thing. But what does it mean? I'll start with you, Martin.
Okay.
Where from this? And what could be the real motive behind this?
I think it is not in doubt that Asiedu Nketiah will be running for, will be contesting their NDC primaries to be president of Ghana, right? So he wants to become flag bearer of the NDC. So for me, straight away, I think that is the bigger reason. Of course, it's also good for him to say thank you. You know, in our culture, we put a lot of premium on gratitude. You have
That
to
has
share.
been done. The president has done that.
But when they went around campaigning, it wasn't the president alone who went. So since Asiedu Nketiah also did, yeah. So
Then the general secretary should also go on a thank you tour. Youth organizer should follow. They all campaigned.
Yeah.
Vice president should go on a thank you tour.
I see what you mean. Yeah, I see what you mean. But so that's why I said that in terms of proportionality, I think the presidential ambitions loom largest amongst the various reasons. Yes.
Will this help?
Oh, absolutely.
If that's what he wants.
Absolutely, because it's like he's hitting the ground running. So you have to go and smoothen the grounds, register your presence first before the others come. So the early bird catches the worm. So I think that's what he's doing. Yes.
Kofi, could this be a new convention that sweeps the political front? Chairman also going out there and saying thank you to reinforce
It is a new
the original
convention.
thank
It is
you.
a new thing, and I'll explain that. Permit me. There's a very important point that I have to make. I couldn't make it earlier. See,
Right.
in our constitution, the Auditor General has the legal authority in our constitution, Article 187, to finally make determinations on audit. And this matter was finalized. There's a final report on it, so the proper body put pay to it. They resolved it. So it is not good to resurrect something that a statutory body has rested and to use it to remove somebody as high as the CJ. And therefore, not good to also use it to remove her as also a judge. So on that point, we should reflect very carefully that when we give authority to institutions to do something and they've done it, we should not using another committee who does not have the same facilities and authority to undo what they've done and proceed to use it to do even further things which are also questionable. That said, honestly, I don't get clear. There is clearly a new trend of thank you talk. Nobody is in doubt that it is a campaign. So maybe what they should do is call it what it is. Then again, it should lead to better systems within our political parties. And I'm keeping it at that level because I think the political parties must have rules about when to start their campaigning and some of those things to sanitize that space. It's something that we are seeing across the political parties. At a national level, because of certain freedoms, I don't think you can tell somebody when to campaign and when not to campaign. But we should start thinking through these things because there is some negative effect of campaigns never ending. But as to what Asiedu Nketiah and co are doing, I think nobody is in doubt that the campaign for the next election has started in earnest, including those who are having keep fit exercises and all those things. We all see what is going on.
Let me ask you this: if indeed what Asiedu Nketiah is doing is just a disguised campaign, does that have an effect on the presidency or John Mahama's presidency? Does it undermine it?
The word undermine is too strong, but to say it doesn't have an effect is to be too simplistic. When somebody is campaigning to replace you, and you know that your performance will be a referendum on them, it brings you into conflict. What it means is that Asiedu Nketiah and others have a stake in what John Mahama does today. All right? And he is the chairman of the party. You can't expect that he will perform his role as a chairman in a sterile way, devoid of any consideration for his own political future. Now, to the extent that he is running the chairmanship for his benefits, is he doing the job that he is intended to do as a chairman of the NDC and also to support the president in whatever way he can, or he's going to work in his own self-interest? I have no doubt that he will work in his self-interest. That raises issue.
Martin, I'll give you the last word. Do you think Asiedu Nketiah can become president of Ghana?
That's a very big one. Yeah.
I thought that saved the best for us.
This one. You see, let's go this way. Scientific. Yeah, let's be scientific about it. Yes, it's possible, okay, for him to become president because, the NDC still has a lot of goodwill, right? If you look at the difference between the votes garnered by John Mahama and Mahmoud Bawumia, it's over 1.6 million votes, right? So, because of that goodwill, it's in our political history, it looks like it's impossible to wipe away 1.6 million votes in one electoral cycle. That's to say, in the next 4 years. So, to that extent, Asiedu Nketiah, if he wins the primaries, he can, because that means that the whole party machinery and even John Mahama himself will now come behind him. Yes. So that one is easy. I think, I now see that your question is easier. I think my mind was on the primaries. Yes, because the primaries is
what the issue is.
But as for the national one, when they finish winning, I think, because it's first past the post 50+1, he can scrape through. And look, let's be blunt, okay? I don't run away from this fact. The main thing, the elephant in the room is that when it comes to optics, generally, speaking bluntly, the issue is that Asiedu Nketiah doesn't usually look the part, okay? Yes, that's speaking bluntly. So that's where it is. But I'm sure it can be managed, because then we'll look beyond optics. People have said it several times that Akufo-Addo came with back in the end. With his this. You say we shouldn't say slangs. Yesterday,
I say it right.
Say it right. Yesterday, I listened to you. Yeah, we all heard when Akufo-Addo was coming. Hey, so Otibrofo. Hey, the man, he gets swag. Where did we land? We ended up the West president, corruption, press freedom, all the indices, economy, everything we tanked. So it means that there will come a time where we may have to look beyond the optics. Yes. And there's this video, maybe viewers can go online and see, where Rollins stated. As I said, look, it's good we are blunt so that maybe we'll get to the bottom of it. Rollins said, Asiedu Nketiah looks good, in terms of on the ground, but yes, that's what Rollins said. He said, but I'm sure with time, if the party says yes, he should go, that can be done.
Doesn't matter that his competitors, the other people who we know are interested, are not doing this. They are busy working. They are in the office. They are doing their job.
They are also doing Keep Faith clubs. Look, let's be blunt once again.
His
main
Keep Faith club on the weekend. We all do it.
The value
it doesn't stop us from doing our job. But thank you, Tor, of the whole country, funded by nobody knows.
Yeah.
That's different, isn't it?
The value is the same. For me, I think they are all, putting themselves in a kind of a pole position to win. Yes, they are jostling for the attention of the delegates.
Right.
Yes.
Okay. Martin Kpebu and Kofi Bentil, thank you both so much for a rather engaging morning. We appreciate it so much. More after these.